Good afternoon, everyone, and welcome to our panel on the reform of canon law and its effect in relationship with the sexual abuse scandals in the Roman Catholic Church. My name is Patrick Hornbeck. I'm a professor of theology here at Fordham University and a member of the leadership team for the initiative Taking Responsibility: Jesuit Educational Institutions Confront the Causes and Legacy of Clergy Sexual Abuse. This is a multidisciplinary initiative here at Fordham University. It's in partnership with more than 2/3 of the Jesuit colleges and universities here in the US, beginning to look at the ways in which the sexual abuse, not just of minors, but of vulnerable persons and other persons, has affected Jesuit higher education, the Roman Catholic Church, and the broader communities that the Church and its institutions serve. Today, I'm privileged to serve as the moderator for this panel, looking at theological and canon law ramifications of a recent change Pope Francis announced to Book 6 of the Code of Canon Law. Those revisions, which have been under study since 2007, affect the way in which canon law deals with sexual abuse and other crimes committed by clergy and lay ministers within the Roman Catholic Church. We have a terrific panel of outstanding experts assembled to help us understand what these reforms mean, where they might have come from, and what their implications will be as the Catholic Church and religious institutions around the world continue to think about dealing with the causes and legacy of sexual abuse. I see that we have participants joining us from all around the world, including from some of our partner institutions. And at this point in the COVID-19 pandemic, I imagine that we are all far too familiar with the logistics of Zoom. But just as a quick recap for those of you who may be new or may not be used to this particular format. In a few minutes, I'll ask each of our panelists to make a brief opening statement. We'll have some questions and answers that I'll be facilitating among the panelists, but we've set aside the last third of the program for your own questions and reflections from the panelists in response to them. So you'll see in the bottom right-hand corner of your screen a Q&A icon. That's where you can submit questions at any point during the conversation, which will come to me. Our experience has been that often there are more questions than there's time to be asked. And so what I will seek to do as best I can is to combine questions that cluster around a common theme and ask the kinds of questions that appear most commonly in the Q&A. If you experience any technical difficulties during this webinar, you can also let us know about those in the Q&A, and one of my colleagues here at the Taking Responsibility Initiative will be glad to help you solve those. As you'll see, this webinar is being recorded, and we'll be making the recording available on the Taking Responsibility website after we've concluded. Of course, one thing that we want to say at the beginning of every event that's taking place in this initiative is that the reality of sexual abuse and sexual misconduct, whether in the Roman Catholic Church or elsewhere, is a serious and important reality that has scarred and affected the lives of many, many people. We know that there are those who are joining us today who may themselves be survivors or friends or allies of victim survivors of sexual abuse. And so we want to extend an invitation, first of all, to anybody to step out as they feel so moved or as they feel it needs to be. And also a deep thanks to those of you who are joining us despite or following on from your own experiences. What I'd like to do is to begin by asking each of our panelists to give an opening statement. I will introduce each panelist briefly before she or he speaks. But what we'll be doing in the meantime is putting in the chat the full biographies of our three panelists so you can read more about them as the webinar goes on. So first we have Sister Helen Costigane. She serves as Program Director for the MA in Theology at St. Mary's University, London. She's a member of the Society of the Holy Child Jesus, who studied at the universities of Glasgow, London, and Leuven in Belgium. And she joined St. Mary's in February of 2017 after 22 years of teaching at Heathrow College, the Jesuit College of the University of London. Her research and teaching interests are wide-ranging, and they include Christian ethics, canon law, pastoral theology, history, and ecclesiology. And as a canon lawyer, Helen provides advice to solicitors, dioceses, clergy, religious, and lay people on canonical issues. And so Helen, I'll hand the floor over to you for your thoughts about what's most significant concerning the revision of Book 6.
I want to start first of all by saying something about canon law itself. As a friend of mine who's a priest said, canon law is a handy wee book. Now, some people say that it's the dark side of the good news, but I think it's really helpful in providing guidelines as to how we live as a community, how we preserve the common good, and at the same time, how we uphold the rights of individuals. Now, the revised code was promulgated in 1983, but of course, things change and develop, and we need to respond to changing circumstances. And these latest changes in Book 6 reflect various issues that have arisen, particularly in relation to the question of sexual abuse, but also financial mismanagement and in the attempted ordination of women. First of all, I think it's interesting that the Apostolic Constitution that promulgated the changes to the code sets the scene and makes a number of important points. It says that the observance of penal law is binding on the whole people of God, but it's the role of bishops to ensure that these rules are obeyed. And we see this reflected in Canon 1341, which says that the ordinary must start a judicial or administrative procedure when pastoral care and warnings have failed. And this is much stronger than what was already in this canon. It said that an ordinary is to take care to initiate a process. So there had been a real beefing up of the role of bishops, as it were. One thing that strikes me is when Francis speaks of the damage done by a failure to appreciate the close relationship existing in the church between the exercise of charity and recourse to disciplinary sanctions. He says negligence on the part of a bishop in resorting to the penal system is a sign that he has failed to carry out his duties honestly and faithfully. My interpretation of this is that he's speaking of what the Jesuit James Campbell labelled as canonical pastoralism. And this was a point picked up by the Australian Royal Commission, which noted that though there were canons in place to deal with perpetrators, these weren't followed. Instead, people were treated by means of informal measures. And in the recommendations in their final report, they asked that the Australian Catholic Bishops' Conference should request the Holy See to amend canon law to ensure that the pastoral approach is not an essential precondition to the commencement of canonical action relating to child sexual abuse. So I think that's a really important aspect. So from now on, it was the case in the past that action was often taken by bishops aware of sexual abuse by priests, by sending the priest to therapy and then restoring him to ministry, moving him from parish to parish in the hope that this would somehow cure him or whatever. And then when action had to be taken, there was a reliance on psychological therapy for suspects of clerical sexual abuse. So there was an issue about injustice for those accused and also the potential victims. I think another significant revision is the new Canon 1398 and the changes to Canon 1395. In what appears to have been a response to the Australian Royal Commission, which mentioned the wording and placement of Canon 1395. This canon had been grouped with other canons under the title Offences against Special Obligations of Clerics, and in this case relating to celibacy. Now, this revised canon has had any reference to minors removed. And there's a new Canon 1398, which appears under the heading Offences against Human Life, Dignity and Liberty. And this spells out in more detail the substance of such an offence against minors or persons who are vulnerable. And it includes other offences like grooming, distribution and of pornography, and so on and so forth. In addition, it's interesting to see that the revised penal law includes not only references to men and women religious, but also lay people, which didn't appear before, really. And it recognises, I think, that lay people have an increasingly important role to play in the institutional church. So it's not just clerics who have access to vulnerable people, but also religious, priests and brothers, sisters, and also lay people. A question for me, though, and I don't think this has been resolved, is what constitutes a vulnerable adult? Now, it talks about those habitually with an use of reason, an impaired use of reason and so on. But I think that there is a distinction to be made in terms of adults in situations of vulnerability, where they might be in crisis and seeking pastoral or spiritual support. Perhaps there's a positional power imbalance, for example, somebody receiving spiritual direction, or a seminarian or a parishioner, or an adult in a context of a personal power imbalance, suffering from anxiety, depression, or trauma, for example. I'm carefully watching my stopwatch here to make sure I don't go on for too long. I think the other thing that struck me that's been very significant is Canon 1321, the sentence at the beginning: any person is considered innocent until the contrary is proven. And I think certainly in England and Wales, the presumption was that they're guilty until proved otherwise, and that was very unfortunate. So I'll be interested to see how that plays out in reality. I noticed that there's a reference to the pontifical secret as well, which does raise questions about how whistleblowers are protected and so on. But I know that Pope Francis removed the issue of child sexual abuse from under the pontifical secret. So I think that's me done 7 minutes and 6 seconds. So I'll pause there.
Helen, thank you so much. And you've touched on a number of issues I know that we'll be returning to in this discussion. It's my privilege now to introduce Father John Beale, our second panelist, who's a presbyter of the Diocese of Erie here in the United States, who holds a doctorate in canon law from the Catholic University of America. He served as judicial vicar in Erie for 8 years and subsequently joined the faculty of canon law at Catholic University, where he's presently an ordinary professor and the Stephen Kuttner Distinguished Professor of Canon Law. He was a co-editor of and contributor to a new commentary on the Code of Canon Law published in 2000. So John, we're eager for your initial thoughts as well.
Well, thank you. The late Aidan Kavanaugh described canon law as the set of rules that provide for the good order and the due processes of the Christian community to tie it continuously to the 3 great canons of Scripture, Creed, and Eucharistic prayer. Less elegantly, my former colleague Jim Provost used to say that the role of canon lawyers in the church is a bit like the little fellow who comes along behind the elephants in the circus parade and cleans up after them. And that sometimes is what canon law tries to do, and particularly in this area where we have struggled with the issue of the sexual abuse of minors. Canon lawyers have been called upon to try to provide the rules and the processes by which this situation can be addressed to restore justice in the church. The new or the revised Book 6 of the Code has a number of significant features, I think. Helen has touched on some of them. I would just add a couple that I think are particularly significant. There is a new Canon 1395, Section 3, that deals with situations that we have encountered in the church with regard to adults who have been abused by clerics or others in ministry through threats. It was particularly prominent in the cases of Cardinal McCarrick, who used his position of authority to lean on seminarians and other adults to engage in sexual acts. It was also somewhat part of the problem with Bishop Bransfield in Wheeling, Charleston, West Virginia. This allows for the punishment of people who abuse clerics who abuse their authority. And it also extends it later on in Canon 1398 to other people in positions of ministry in the church, even if they are religious or lay people who do a similar thing. I think that's a significant addition to the law. In addition to finally articulating the norm that canon law bequeathed to the English-speaking legal system, that the person is innocent until proven guilty, there is an attempt in the new penal law to provide adequate procedural protections for those who have been accused when the penalty is being imposed through an extrajudicial or administrative process rather than a judicial trial. The protections in the the judicial process are fairly adequate, but the administrative process has been used increasingly by the Congregation for the Doctrine of the Faith to deal with these cases now, and the protections of the accused have been sometimes trampled on. I think also a significant addition to the law in this revised form is the emphasis on negligence by those in authority. There was only one canon that I can recall in the previous penal law that provided a penalty for negligence in the exercise of authority, and there are several in the present canon. Now, we don't have a particularly well-developed jurisprudence on what constitutes negligence. It's been somewhat ignored because the previous code and the code before that did not emphasize it. But I think it's an important addition for dealing with cases where reports of sexual abuse of minors and other offenses have been ignored or brushed aside. So I think those are three significant new parts of the revised penal law.
John, thank you so much for that, and we'll certainly come back to those themes as well. But it's my privilege now to introduce our third panelist, Jennifer Haselberger. She's practiced as a canon lawyer in the United States and internationally. After serving as the bishop's delegate for canonical affairs in the Diocese of Fargo, Dr. Haselberger returned to the Archdiocese of St. Paul in Minneapolis to serve as chancellor for canonical affairs, a position that she held until resigning in April of 2013 in protest of the Archdiocese's handlings of accusations of clergy sexual abuse. In 2013, Dr. Haselberger established Canonical Consultation and Services, LLC. Jennifer, thank you so much for joining us.
Thank you. Thanks for the invitation. And also, I want to thank Fordham's Office of Diversity and Inclusion, because with their assistance, I will be donating my honorarium today to the LGBT Student Alliances and to the 6 Black Catholic organizations on campus, as a sign of my solidarity and the importance of those issues for the church and the world at large. I also want to thank Helen and John for their really excellent analysis of the code, and also for the work you've done on behalf of the church and canon law. I have nothing but respect for the work that you've done, even while I might disagree with some of your positions. And I should start by saying that no one prior to this meeting today has really asked me about my thoughts on the revision of canon law. I wasn't involved in any of the consultations. I wasn't part of any of the work that was done. I didn't particularly expect to be, but I feel it's important to say that because that hasn't prevented me from saying for a long time where I think the issues were and what needed to be done. And I say that because I'm not, or at least I wasn't at the time, an academic. I was somebody who was working very practically in chanceries and dioceses to really address and try and use canon law to resolve the issues that we were seeing. So I wasn't invited beforehand, and now I find myself in the role of a critic, but I see some value in that. I also have to acknowledge that not being consulted is probably my own fault, because if you would have asked me starting in 2007, I would have probably told you what I thought the church could do if they really wanted to get a handle on penal matters in the church was bring back trial by ordeal. And while I was joking to a certain extent about that, there's also some truth in what I was saying. And I'm happy during the question period to go a little bit more in depth with that. But there's two issues that were always a source of frustration to me. And the first is the burden that canonical processes put on the victims to prove and prosecute their crimes. And obviously, I realize the role that that has in law in general, but I think there isn't a lot of recognition of the unethical conduct of the church in preventing them from doing that. Concealing evidence, lying under oath, moving offenders from jurisdictions, the barriers that the institutional church has put up to prevent people from seeking justice, I think has to be acknowledged. The other thing is, I think when I say we should bring back trial by ordeal, it's because I want to make sure that we don't fall into the trap of looking at canon law as some sort of enlightened, equal system of canon law. Because frankly, it's not, right? I appreciate everything that's said about the need to for people to be innocent until proven guilty and to protect the rights of defense. But the church is not very good at applying the general principles of law across the board. It does so when it's to its advantage to do so and sets it aside when it's not. And so I think talking about our history and things like trial by ordeal is kind of a necessary corrective to what we're really talking about when we're talking about canon law. And trial by ordeal would be huge on TikTok. But let me shift to something else that I think kind of demonstrates what I'm saying. So when we talk about sexual crimes by clergy, we talk a lot about the most severe penalty that the church can impose. And whether it's journalists, commentators, bishops, it doesn't matter. We routinely tell people that the most severe penalty the church can impose is dismissal from the clerical state. Now let's just stop and think about that right now. Because what that is saying is that the church considers the worst penalty that it can inflict on a cleric to be to make them like the rest of us. But a slightly better version, because as this new book emphasizes, you can never lose the power of orders. So even though you're dismissed from the clerical state, you can still administer the sacraments, and anybody who's seen a decree of dismissal knows you can still receive them. So a dismissed priest is still able to marry, even though a Catholic who's married outside of the church after divorce cannot. So I think these are important things to keep in mind. So if dismissal from the clerical state isn't the greatest penalty in the church, what is? Well, theologically and historically, that's always been excommunication. And excommunication does remain in this new book as a penalty, but it's not a penalty for sexual abuse of minors. It's not a penalty for failing to properly respond to accusations of sexual abuse of minors. And it's not a penalty for any other sexual crimes by clergy. And I think we need to sit with that for a minute. And then we can ask the reverse. So when is that penalty applied? Ordination of women, abortion, certain crimes involving the sacrament of the Eucharist, like consecrating one species, not the other, absolving an accomplice. So I think we have to ask, what are the principles and the ideas that are underpinning this revision, and whether they're still useful and appropriate. Now, I'm sure a lot of you who aren't, don't follow the history of canon law and things are wondering why I would say excommunication is the most severe penalty. But historically, it was called the eternal separation of death, because excommunication historically not only barred the offender from receiving the sacraments, it barred them from the company of other Christian people. It was social ostracism, humiliation. You couldn't eat with them. You couldn't greet them in the streets. They could go into churches that were empty alone, but they couldn't even stand outside a church during Mass. They couldn't own property. They couldn't make a will. This was quite literally the most serious disaster that could happen to someone. It impacted all aspects of their life on this planet and everything we thought was true about the afterlife as well. And I would just point out that this was true in canon law until 1983. The prohibition on communicating with an excommunicant was still part of the 1917 code. So it also, and this I think is really important, one of the effects of excommunication in the 83 code and even in the new revision is that people who are excommunicated can't receive remuneration from the church, which we know is not the case with clerics who are dismissed or given prayer of penance or anything like that. And that is a fact in the new book 6 as well. So I would argue excommunication, even as it stands, is far more restrictive than what dismissal from a clerical state is. So I would like to see excommunication being the penalty that's imposed. I also want to talk about how there's a ritual aspect of it. And it's a chance, I mean, me, frankly, I'd like to go back to the old days with the turning upside down of the candles and the rending of garments and the ash and the ritual expelling. But what an awesome opportunity have we missed for standing in solidarity with the victims of abuse. I mean, can you imagine the message that would send if we all publicly turned away from the people who have committed these crimes for as long as they remain under their edict, right? So the kind of glory of excommunication in the church is that it requires the offender to make reparation, to amend their behavior in order to be brought back. Now, that doesn't mean that we can't also impose perpetual penalties in addition to excommunication, right? If the circumstance warranted, and I would say with sexual abuse of minors, it always will, dismissal could still be a part of that, right? That's another penalty, that's part of the penance, that's fine. But the point is, it gives us a ritual opportunity to stand with victims and to center their experience as well as the harm that was done to community, right? As a voluntary society, all we have that binds us together is the principles and the rituals of that we're organized around. And to remove somebody from that, to say that your actions mean, until you fix the problem that you've created, your actions mean that you can't be a part of this community. I think that leaving that on the table and not considering that and making it a part of the penalties, I think was a mistake. I know I'm probably going over. I just want to make a few additional points quickly about areas that I think were missed with this revision. I can't help noticing that even though we do now have canons on financial crimes, that it doesn't include financial exploitation of the elderly, which certainly in the United States is a problem that needs to be addressed, but I'm sure is also an issue other places. I'm also more than a little frustrated by the fact that 1395 still requires the warning. And I think Helen talked a little bit about this, about the pastoral having to come before the penal. So we have a situation under 1395 where a priest who engages in a a sexual crime that doesn't involve the sexual abuse of a minor, he has to be warned to stop before a penalty can be imposed. Well, in my experience of chancery work, by the time we learn of the issue to issue the warning, the problem has already happened, right? I mean, it's a severe issue, the harm has been done. I would also argue that since Latin Rite clergy are under an obligation to maintain perfect and perpetual continence, that they've already been warned, right? I mean, they know. So I think what we're seeing there is a reflection of that idea that priests aren't so much violating their obligation, is like led astray, usually by devious women. I think you really see that in that canon. I think that needs to change. I would also say that while I admire the intention between 1397, 1 and 2, where they talk about grooming and producing pornography, I think that is admirable. I don't have a lot of faith of it being applied. And with the sexual crimes, I'm also frustrated that there's no acknowledgement of prostitution or sex trafficking. I don't want to see penalties against women or others who are forced into that position. I absolutely want to see that considered in penalties imposed on clergy. And then I just have one more thing that I want to talk about, especially Patrick, since you did such a great job of pointing out that we have these canons on human dignity and valuing life, which again include things like abortion. Where is the prohibition against inciting hatred against individuals or groups on the basis of race, religion, sexual orientation, gender expression, physical disability? Wouldn't it have made sense at this moment for the church to have included in crimes against human dignity and life, participating and cooperating in genocide or enslavement? I mean, isn't it time? And what about capital punishment? So again, I'm grateful for all the work that went into this project, but I think Francis could have done better.
Jennifer, thank you so much for giving us so much to think about. And on behalf of Fordham, let me thank you for your generosity to our LGBTQ+ and Black student groups as well. That's incredibly gracious of you. I see that Helen has dropped off the call unexpectedly, so I'm hoping that that will be a temporary technical issue that will be restored in just a moment. So what I'd like to propose that we do while we're waiting for Helen to come back, let's just take one sort of big step back, and John, I'll address this question to you, which is to ask if you could say a few words about how long these changes to Book 6 of the Code have been in the works. And even in the title of this panel, we referred to it as changes that Pope Francis has promulgated. Of course, that's true. But since these changes began under the pontificate of Benedict XVI, to what extent should we think about these as Benedict's changes, Francis's changes, the church's changes? Can you walk us through a little bit of the history here?
I can try. A lot of it has been fairly opaque, but from the early 2000s, it has been apparent, or it was apparent, that the penal law system in Book 5 of the 1983 Code was inadequate to the sort of things that were being part of the life of the church. And so a movement that began, I believe, in the Council for Legislative Texts in the Roman Curia began to look at the revision. So it has been actively underway for at least 15 years. I can recall back in someplace between 2005 and 2010, as one of the hazards of being part of a faculty of canon law, we were sent a draft of this document to offer suggestions on. So it's been underway. I was in Rome for a meeting of the Pontifical Council on the Protection of Youth back in 2019. and the representatives for the Council for Legislative Texts that were present at the meeting indicated that the revised draft of the Book 6 was on the desk of the Holy Father. So it began well before the pontificate of Francis. It reflects the concerns of Benedict, but I really think it reflects more the concerns of Rome-based canon lawyers who are more interested really in perfecting the system from a legal perspective than in dealing with pastoral issues. That's my take on it.
John, thank you so much. Helen, I'd love to follow up with some points that you raised in your opening statement that I think both of the other panelists echoed. So you were talking about Canon 1321 and the presumption of innocence. Those of us who are in the Anglo-American system, of course, are used to hearing the maxim, of course, that a person is innocent until proven guilty. And I'm wondering if you could talk about how you see canon law allocating the various burdens that occur in a claim, let's say, being made by a victim survivor of sexual abuse. So Jennifer was talking a few minutes ago about the burdens that a victim experiences in bringing something forward. You were talking about the burden of proof and the procedural protections that are due to the accused. And as you were both speaking, one of the things that was running through my mind was here in the United States, when the US bishops adopted the Dallas Charter, there was, at least in theory, a certain zero tolerance approach that was involved. And so I'm wondering if you could help us think about the various burdens that exist in this context. On my screen, it looks like Helen is frozen, I'm afraid. Either that or she's thinking very hard about my question, but I have a feeling it's a technical problem. So John or Jennifer, can I throw that question to you about the different burdens with regard to the accused and the accuser, and then maybe hopefully Helen will come back.
Well, I mean, I think one of the most interesting elements of that has to do with accusations made against deceased clergy. And I say that because this is where we see the church really upholding to very strong degrees the idea that you're innocent until proven guilty. And of course, when you have deceased clergy, they can't defend themselves. And so there have been numerous cases where the evidence is overwhelming in favor of the abuse occurred, but there isn't the acknowledgement of that, especially in things like naming them on the names of lists of publicly accused, because of this idea that we have to protect we have to protect this right. And again, if we were talking about a system of law that universally upheld the rights of individuals, I wouldn't have anything to say about that. But we're not. We can do this at will. And, you know, theologically, we also think that the person who is being accused after death is in a place that this is no longer a concern for them. So, you know, I would like someone to defend for me this practice.
Helen, I know you just joined, you just came back. I don't know if you heard my entire question. I know you missed some of Jennifer's response, but it was about the burdens. If I could invite you to unmute yourself, I'd love to hear any thoughts that you have.
Sorry, say again, it was about the idea of presumption of innocence, yes?
Well, and the different burdens that exist, the burden on the complainant, the person coming forward, and how canon law weighs up the presumption of innocence and other procedural protections you were talking about versus.
Yeah.
Go ahead.
You see, in England and Wales, we had the Nolan Report, which put things into place, and then that was modified by the Cumberland Report. And how that worked in practice was that the minute there was a sniff of an allegation against a priest, he was immediately removed from his presbytery and didn't get any accommodation, no help with legal fees, whatever. So there was a real injustice that went on there. I think the pendulum swung at one stage that any kind of accusation was believed, you know, and that led to tremendous injustice. I think victims have been listened to, certainly in England and Wales. But, you know, we had the independent inquiry into child sexual abuse, and that was very, very wide-ranging. But actually, it showed up where particular places where they weren't listened to. I know that a number of religious congregations didn't think that Canon 1717 applied to them. That's whenever there's a hint of abuse there, to open a preliminary inquiry, or it was, you know, a full-blown thing. So that the canons weren't used properly. That's part of the issue, I think. But I think in general, people were listened to and taken seriously. Certainly in this country, not always, of course, not always, but I think in later years, certainly with the Nolan report that came in, that's about 20 years ago now, everybody was listened to, and the problem was that priests were suspended and left in limbo for a long time without financial support or anything like that. So so I'm glad to see that there is this presumption of innocence. I don't think it'll make a difference in terms of the victims won't be listened to. They will be listened to, but I think it'll be much more balanced now.
So thanks, Helen. And I want to call on Jennifer in a second, but let me just mention one theme that's coming to mind for me. You've mentioned, Helen, the inquiry that occurred in England and Wales. We've heard a little bit about the Australian Commission. Here in the US, of course, there have been a number of investigations, perhaps most prominently the Pennsylvania grand jury report. And obviously this is a panel on canon law, so the church's law, but I'm wondering, and Jennifer, I'll pivot to you and feel free to integrate this into your answer as you wish. What do you think, if any, has been the effect of these civil law investigations on the way in which the church has thought about revising its own canon law?
Hey, thank you, Patrick, because that's really something that I want to talk about. But thank you, Helen. You made some really good points, because as somebody who was very heavily involved in these circumstances and prosecutions, they were taking years and years and years. And I agree 100% that that was unjust and unfair. Although in the United States, it was very rare that they were without financial support during that time. But I want to talk a little bit about kind of some of the underlying presumptions, things that don't appear in canon law now, but have always been part of the church's teaching, right? And that is an underlying understanding that the most valuable thing to a priest in the church is his reputation, right? Because in the mind of the church, if a priest loses his reputation, he's worthless. And that's wrong on a lot of levels. But if you look back into some of the non-codified regulations and edicts, and especially around penal processes in the United States and in Europe, you had prohibitions against lay people bringing cases against clergy. You had rules that said if they did, or if there were allegations of clergy, that you had to have 3 or 4 lay people to kind of have the same weight of evidence as one cleric. Because there was this idea that lay people their conversation and their opinions didn't have as much weight. And I think a lot of that still underlines these processes. But also, you know, I think all 3 of us here have, and Patrick as well, we have doctorates and advanced degrees. We've lived within the church. We know its structures. It might seem to us as if it's easy to bring a claim. But if you are someone outside that, it's not easy. It's not easy at all. I mean, just the enormous amount of courage it takes for them to do it. And I think, to get to your question, Patrick, that's an important thing that we acknowledge, because we keep going back to all of the work that was done by these civil criminal investigations and the people who came forward to them. Well, there's a reason that they chose to come forward to those organizations and not to us, not to the church. So, you know, again, I think this gets to the burden. And you can say, you know, I know they have websites and things that have been set up to make reporting easy. But again, that's presuming a level of competence, a level of access that I think is probably not as useful as we want to pretend.
Jennifer, thank you so much. And I want to just remind everybody who's joining us for this webinar that the Q&A feature is available at the bottom of the screen, and we're continuing to collect your questions, for which we're very grateful, and we'll come to those in just a few minutes. John, I'd like to turn to you on a theme that several of the panelists have raised now, which is this question of a negligence standard. And so for those of us who are sort of formed in the Anglo-American tort law tradition, there's this sense that negligence means something like what the reasonable person wouldn't do, or a violation of the duty that a reasonable person would have. And as Helen mentioned in her previous statement, the revision now, I believe, and I want to make sure I get my language right here, makes it either a delict or some sort of a violation for a bishop to be negligent in resorting to a penal process against a cleric. So I'm wondering if you could comment on sort of maybe unpack some of those categories for us, and what does it mean that there's now this negligence standard for bishops?
Well, it means that they can be removed from office not only if they perform an action that is violative of the law, but if they neglect to do something they're required to do. The previous law had been almost silent about the possibility of punishment for those who failed to carry out what we might call due diligence. Now, one of the problems with dealing with negligence in the church is we have a rather underdeveloped sense of agency for making people responsible for the acts of others. That's highly developed in American tort law. It's not so well developed for a variety of reasons in canon law. But the present law does at least begin the process of holding people to account not only for what they do, but for what they fail to do. But here, as in lots of other areas of the law that touch on the sexual abuse of minors, the problem now is, are we willing to move forward with this? I have been involved in some way or another in dealing with claims of sexual abuse by clergy and others since the early 1990s. And just about the time I get to think, now we've got at least the procedures in place for dealing with this, something blows up and I find myself asking, didn't they get the message? It seems like we're always going back to square one to start all over again. And I am happy to see these provisions for punishing people for negligent behavior in the revised penal law, but I would like to see them actually applied to some people who cases warrant it. And I will be elated that it happens, but I'm waiting.
It sounds, John, like in theological terms that one way to think about what you just said is the difference between a sin of omission and a sin of commission.
Yes.
And that raising, creating a negligence standard for what we might think of as omissions is important, but only insofar as it's possible for church officials to enforce this. And I see in some of our audience questions already that people have raised the issue of what are these reforms like if in fact they're not enforced. In fact, in their response to the promulgation of Book 6, the executive team at the Survivors Network of Those Abused by Priests wrote the following: this is an important step forward in acknowledging the true scope of abuse within the Catholic Church. The changes announced by the Vatican are only as good as their enforcement. So Helen, let me come to you on this. One of the points that you raised, I believe, at the very beginning was to say that it's good that the new book 6 has this phrase "vulnerable adults" in it. But one of the questions that arises when it comes to enforcing the new book 6 is what exactly do we mean by vulnerable adults? So first of all, I don't want to put you on the spot, but how would you define that term? And how do you expect that those who will be enforcing these laws will define that term?
Yeah, I know that in the revised canons it talks about persons who habitually lack the use of reason. But I think there's an argument to be said that we need to be talking about adults in situations of vulnerability, because one of the things that I'm seeing now is claims of not sexual abuse, but spiritual abuse. And I think that's the next thing that's going to come down the train tracks. And I've certainly seen allegations of it in religious congregations, for example. And I'm just wondering how long it will be before a parishioner makes a claim against a priest who gives a homily haranguing them what constitutes spiritual abuse. And I think that's going to be another issue. I think we need to look at power imbalance because the people still look up to priests, I think, and religious, God help us. And we need to acknowledge that we have power and that we can misuse it, even though we might not think we're doing that. So I think, people, and they're talking about this idea of persons with habitual use of reason. I don't think this, or lack of reason, I don't think it goes nearly far enough. I really don't. And I think that really needs to be expanded because people in crisis might not be vulnerable adults in the kind of care terms that we talk about, but there's certainly scope for abuse there. And also the idea that I think it was Jennifer raised about financial exploitation of elderly people. I think that's a good thing. How we define it, I think there's a lot of work has yet to be done on how we interpret these canons and what they look like in reality.
Jennifer, I'd love to come to you on this. Go right ahead.
So first of all, I apologize because one of the things I had meant to address is just what Helen is talking about how we put some framework around that. I don't think there's the explicit mention of vulnerable adults, but if I'm wrong about that, please let me know. I also, being in California, California has a very clear definition of somebody who is a dependent adult. And that would be the person who's equivalent to a minor under law. And that definition is somebody who's been admitted as an inpatient to a facility that provides 24-hour care. So think of somebody who's under a hospitalization or something like that. And also the second part of that is somebody who suffers from an ongoing disorder or disability that impacts their ability to make choices and understand consequences. So that is a very, very narrow group of people. And I think if what they mean by those in law is going to defer to what the civil law says, I think, we can look at that as a definition. If we start looking at what the church says about minors, it's going to get even more complicated. But what I would really like to see, and I think it gets to the point that of what Helen is talking about when it's, people who might not have issues with reason, they might not have ongoing mental health issues, but for some reason they're in a position of vulnerability. What I would really like to see is Canon 1395 have a stricter penalty, if you will, when the offender is known to the victim in a ministerial capacity. And I would argue that that should be a rebuttable presumption. In other words, the law presumes that the person is known to the offender because of their ministerial role. And it is for the offender to prove that that's not the case, which leaves open the sex in a hot tub on a vacation, right? To have lesser penalties, but also looks at spiritual direction and acknowledges that people grieving and some of those other situations, because I'm very hesitant to want to apply terms like vulnerability, because that can have other ramifications. what is their value as a witness? What do we make of their testimony if we're forcing them to prove this? So I think, again, let's put the burden where it goes, and let's penalize that ministerial connection.
Well, let me build on that. And I want to make sure, Jennifer, to come back to your very evocative comments from earlier on about penalties in a minute. But hearing both Helen and you speak, I'm thinking a lot about the ramifications of the Me Too movement, not just here in the US, but around the world, and broadening people's understanding of the kinds of vulnerabilities that might exist in even a secular workplace, for instance, as with the Harvey Weinstein case or otherwise. So I'm wondering, and I'm happy for any of the three of you to speak to this, what lessons there are for the church to learn from secular advocates against sexual harassment, sexual violence like Me Too? And then are there places where the analogy breaks down or the analogy doesn't work quite as well because of the religious context?
I think one of the issues is access. I dealt with an abuse case within a particular congregation. And one of the issues was how could as the sister in remote locations actually access somebody who could help her, because they didn't have phones, they didn't have email, and so on. So, and I think that's a big issue. And I'm seeing more of this emerging, this Me Too, in terms of religious congregations, which in the past would maybe have been not even acknowledged. But I remember saying about 20 years ago, I was giving a conference and an older sister said, I'm bullied within my community. And we talked about how to deal with that. And I thought, that's interesting. I mean, if she's one case, there might be others. How do you enable people to be able to report things? And it's okay if you're articulate, you've got lines of communication and so on. But how do we, if you like, legislate for, say, religious congregations to ensure that they have correct lines of communication and are not dependent on having to go to the superior who may well be abusing them? So that's something that's crossed my mind.
Thanks for that. Jennifer, I saw you unmuted yourself as well.
If you don't mind, because I think, Helen makes a great point. And again, I was down and dirty in this thing for a long time. And one of the very first cases I worked in was a priest who was a confessor and spiritual director for a congregation of religious women. And, the victims were, I think there was 20 to 30 different victims. And one of the most incredible moments in that is one of the victims, who was a minor at the time, her superior actually came forward and supported her allegations and said, she told me at the time, but there was nothing I could do, and made that apology. And so I think that is really an important aspect.
Thanks, Jennifer. I see I want to make sure that we are turning to the comments and questions that people are sending in. So, John, I'd like to direct this first one to you. And there's been a number of comments made about Vos Estis Lux Mundi, which is not exactly part of Book 6, if I understand correctly, but a different set of guidelines and rules promulgated by the Pope with regard to the obligations of bishops. Mm-hmm. And so one of our audience members is wondering, first of all, is there an obligation for a diocese or archdiocese or religious congregation to provide support to victims? If not, is that a Vos Estis violation? If a victim survivor doesn't receive any kind of reply, where exactly is that person supposed to go? And in the canon law system, is there provision for something like assistance of counsel, like we might have in the civil law system, where someone might be entitled to counsel?
Well, Vos Estis remains part of the law of the church, although it is substantially outside this Book 6 of the Code, as it was previously. Vos Estis does call for those who come forward with accusations to be provided with appropriate support. But like much of church law, it depends on the benevolence of the person in authority to determine what that is. in theory, the person who comes forward and is not given adequate support could make recourse to the person's superior, but I'm not sure how realistic that is as a remedy. So in principle, it is to be provided, but how much that is going to make sense in practice, I don't know. One of the real problems, of course, is that once in the system as it is set up, once the victim makes his or her complaint known to the person in authority, makes the report, and has a deposition or statement taken, the system sort of loses interest in them. There is a provision, never used as far as I know, for the victim to join a penal process in claiming damages, something that has been much emphasized by Archbishop Scicluna, but I've never heard of it being told to a victim as a possibility for them, and how it would actually work with cases that were dealt with at the level of the Holy See, I'm not sure. But so the victim makes his or her report, the case gets underway, and then nothing happens with regard to the victim. Vos Estis does provide that if he or she asks, he or she can receive a notice of what has happened with the case, only if they ask, and it provides that they can have an advocate, although it doesn't provide much information about that. But the case will run along to its end without the involvement of the victim at all. And I think that can contribute even worse to the frustration of the victim of thinking that nothing has happened as a result of what I did, and nobody cared about me because they have just sort of been left hanging once they made their report. Partly because the whole process unfolds under a cloud, unlike, you've got a similar setup in Anglo-American systems where the district attorney decides whether to bring charges, and then there's a public trial at which the victim can be present and see what actually happens and know the outcome. And perhaps in the many jurisdictions at the penalty phase of the trial, there can be a input from the victim or victims to help judge what penalty seems appropriate. But none of that is available in the canonical system. So once they make their report, the system forgets about them. And it becomes incumbent on the victim to get what little information the law is willing to provide to them. It's quite inadequate.
Yeah, that metaphor of the system forgetting seems so evocative to me of so much that's gone into the feelings that victim survivors have. Jennifer, I see you want to speak. If I could ask you to be brief, and then there are questions coming in over the transom from our audience.
And I just wanted to say that I agree with John in what he's saying. And that's why the penal processes and the imposition of dismissal has been so unsatisfactory. Again, you need a process that centers the experience of victims and makes their healing and reconciliation with the community the focus.
Thanks so much. And one of our audience members points out that the Australian Commission reached the conclusion that when people didn't know the results of an accusation, that actually became a disincentive to reporting. And I think that makes a great deal of sense. Helen, I think I'll come to you for this next one. So an audience member asks, why is there not consistency in the diocesan review boards? And I would add into this as well, review boards that might exist, for instance, in religious orders that handle the internal review of claims of sexual abuse by clergy. Are there movements to standardize, to create greater levels of consistency about what a credible accusation might be, what a vulnerable person might be? Are there ways to make this more aligned going forward?
Well, certainly in England and Wales, after the independent inquiry, the whole of safeguarding has been totally reviewed with new agencies. There will be a national tribunal to hear cases. So that should make a difference, because it's a countrywide approach, as it were, so to standardize things across the different dioceses, and I think that will make a big difference. I think one of the issues, of course, is the funding of it, and religious communities are a bit annoyed at having to fund the national tribunal when it's actually the men who've been accused more. But anyway, it is what it is. But I think that will make a big difference, because the inquiry, identified very structural issues, and they're being addressed now.
Thank you so much. I want to follow up on with John or Helen on a point that Jennifer had made earlier on in this webinar. And just to summarize what I took Jennifer's point to be, was to say that if dismissal from the clerical state is thought of as the most severe punishment that's available, on the one hand, that seems to reinforce or reify a sort of clericalism. And on the other hand, seems to miss out on a very rich tradition that's existed within Christianity for quite some time with regard to the far more severe penalty, or potentially more severe penalty, of excommunication. So John, I'll come to you first on this, and then Helen. And I guess the way I would frame the question would just be to say, do you think the penalties that the revision of Book 6 associates with any of the things that we've been talking about, are those penalties adequate? Would you revise them in some other direction? What's your thinking about this question of penalties?
I think that the penalties provided are quite traditional, and they don't really move very far, other than extending some of them to things that might apply to lay people, and to provide for the possibility of a fine as part of the penalty, which had not been in the law before. I am intrigued by Jennifer's suggestion that excommunication be imposed. It is classified in the law as a medicinal penalty that has to be removed when the person shows adequate repentance. I think perhaps the obstacle is that we have been remiss in really requiring some genuine show of repentance in dealing with these medicinal penalties. We've taken it, and I'm sorry, as a sufficient and therefore thought of the excommunication as an inadequate penalty in these cases, because as soon as they say they're sorry, they have to remit the penalty. If we could come up with a better way of providing for actually making genuine restitution or making restoring justice in cases like this, I think that the idea of imposing excommunications might be a better idea.
Helen, I'm wondering what your thoughts are on this as well.
Well, I often think about that phrase, he was reduced to the lay state, and I thought, what a cheek. And of course, there is an argument which says, well, actually, you shouldn't release them back into society generally, because then who's going to monitor them? I suppose it comes down to a question of what are we looking for in terms of imposing penalties? Is it rehabilitation? And I suppose excommunication, I suppose, can be quite severe. Is that going to achieve the necessary thing? Because I am conscious that when we talk about sex offenders, there's such a wide range under that, that almost no two people are alike. And I think that's the other issue about gradation of crimes as well, because there can be such a wide sweep that we need to take into consideration. And so I think a lot more research has got to be done into why people offend, so that we can actually respond. Because I am into the idea of redemption as well as rehabilitation, but also restitution, repairing the scandal. But I think it's a much wider, more complex issue because of I attended two sessions for sex offenders many years ago, and it really opened my eyes, because I thought there is no such thing as a typical sex offender. You know, they were all so different. And I thought, really, we need to take that into consideration as well. I'm not soft, but I am aware that it's a very, very complex issue.
Thank you so much. One, I'm not sure whether to class it as a penalty or not, but one feature that none of you have mentioned so far is the reporting of accusations by church officials to civil authorities. And I was wondering, I don't read the revised Book 6 to mandate that. Am I right? And do you think that Book 6 should have included something like mandatory reporting? And that can be to any of you.
If it's a crime, then I think certainly there has to be mandatory reporting, because I would see that as negligence. But usually these things come up with the police, well, certainly in this country, with police involvement first of all. So you know, it is reported, and the police or the criminal process is looked at before any canonical process. So in general, I think, but I mean, of course, worldwide, that's a different issue, and maybe that's what it takes. You know, because I think Vos Estes talks about the role of metropolitans. Well, actually, some metropolitans have maybe been negligent in not reporting crimes. So maybe that's a possibility. Yeah.
Jennifer.
So, well, I think you're right. And I think the churches, let's just say the people in Rome, have made some statements about why they choose not to include that. That has to do with clergy in countries where they face persecution and things. I'm not saying I give any weight to that argument. I'm just telling you I think they've addressed that, and that's generally their response. I had the great honor of working with a bishop who reported everything. I mean, we had the local prosecuting attorneys on speed dial. There have been some issues with that in the United States, particularly in the situations involving adults. And do adults have the right to choose whether it's reported outside the church or inside? And that can have consequences for them, especially in some smaller rural communities. So, you know, I think, yes, certainly in the cases involving minors. I'm also pretty, I've been pretty outspoken about the fact that I don't like the church refusing to budge on the issue of knowledge that comes within the confessional. Because in my own experience, and we see in the new Book 6, right? Look at the way the penalties are done for violating the seal. There's some very different levels and some very different presumptions that go along with it. So I'm not particularly taken by any of the church arguments that suggest clergy can't disclose anything that's they're alerted to in a pastoral context, because of course, quite often we have our own internal reporting system for things that happen within the confessional. So if you're doing it internally, I don't know why you can't do it externally.
Thanks, Jennifer. And we're beginning to move into the last phase of our discussion. There'll be a chance for each of our three panelists to offer some concluding thoughts. But one question that has come from an audience member, if we imagine, just as a hypothetical, that the 1983 revision to the Code of Canon Law included this Book 6 and not the previous penal provisions, what, if anything, do you think about the last 4 decades of scandals concerning sexual abuse in the church would have been different?
I don't really think that anything would have been different had this law been promulgated by John Paul II on January 25th, 1983. What is needed to address the issue of the sexual abuse of minors and other offenses in the church is not so much new law. The new law can be helpful and provide tools, but a new mentality. and one that does not give the benefit of the doubt and undue deference to clergy in all circumstances. And that certainly wasn't the case in 1983. So whatever was on the books was going to probably have a response that was not unlike what happened in our own experience. So I think what's really needed is a change of heart, or what Pope Paul VI used to say way back when, a novus habitus mentis.
Thanks, John. One of our audience members comments that in an address to canon lawyers in Australia a few months ago on the topic of reforming the Roman Curia, Monsignor Arieta, who was the person who presented the new book 6 to the press, didn't mention the Pontifical Commission for the Protection of Minors as part of that reform of the Curia. And I'm wondering, and maybe this could be for Helen or for Jennifer, whether you want to speak about this particular instance or more broadly, is that a sign that the change in mentality that John was talking about hasn't happened yet?
Yeah, I think it is. I think as far as I know, I know somebody who's on that committee or resigned from that commission, that they were running into brick walls trying to get anything done. And I don't think it's been taken seriously at all, really. But the other point I would want to make is that when things go to the CDF or to the Congregation for Institutes of Consecrated Life, it takes forever to get a response back. And I have raised this. It seems to, I mean, they'll say we've got very few people, we've got loads of work to do. If you're going to have that as part of the system, you have to fund it, you have to staff it properly, because there's no point in saying, no, you know, we'll have to wait months or even years, or they don't even bother to respond to you. And I think that was one of the issues with this protection of minors dicastery, that they won't get responses from the CDF. So that has to change as well.
Can I just kind of piggyback a little bit on that, because it's more than frustrating. And of course, you know, when you only work between 10 and 4 and take a 4-hour lunch break, you don't get a lot done during the day. But also, you know, they constantly talk about a lack of personnel. Well, gee, maybe if you didn't restrict it to so few people. I mean, well, we don't have the personnel to have penal trials. Well, that's because you only let priests with J.C.Ds do it. I mean, there's lots of other people who can be working on this. And I would also say, or I'd like to remind people, because I agree 100% with John that it wouldn't have made any difference. But, you know, since 2002, when the Charter and the norms in the United States, there has been kind of a nonstop backsliding, right? We never got all the American bishops to even participate in the audit. Mm-hmm. It's been a close run thing every time they've had to vote to re-up things like the one strike you're out policy. Assistance at diocesan levels has been appalling, and bishops feel pretty empowered these days to just not respond to accusations and allegations that are coming in. So, you know, there's more that needs to be done here.
So that's a transition, a stark transition, but one nonetheless. To the last question I'd like to ask each of you, and it actually comes from an audience member. In your opinion, what is the one change that needs to happen for the church to have a sufficiently just legal system? And I see that Jennifer already answered this, so I'll start with her, and maybe you'd like to expand on what you wrote in the chat, and then I'll come to John, and then finally to Helen.
Yeah, and I just pretty much said it as well. I think we've got to really look at the link between the power of orders and the power of governance. That's the principle that keeps lay people from exercising full participation in the church. The idea that you can't govern in the church unless you are also in orders. And then, of course, they limit orders to baptized men. So, you know, I think that change would be significant in dealing with a great number of issues in the church.
Thanks, Jennifer. John, if you had to name one change, what would you think of?
I would agree that we have to have governance structures that include the whole people of God, men and women, ordained and non-ordained, across rich and poor across the board. As long as the decisions are made and power is held tightly by a small group within the church, we're going to have a legal system that serves the interest of that class. You'll notice that the law is structured so that it can be very tough on people at the bottom of the pyramid, and those at the top can wear the law quite lightly. And we need synodality if it is going to work.
John, thank you so much. Helen, last word to you.
Yes, I agree with both John and Jennifer. I think a change of attitude is needed. I think it was, I might not remember this right. I think it was Robert Bellarmine who said the sheep cannot judge the shepherd. And I think that's underlines still a lot of our mentality. And this question of governance, many capable people are not allowed to, or not able to fulfill the talents, as it were, in the service of the church. So that really does have to change of attitude.
Well, thank you all so very much indeed. As we're winding down, I want to just first of all let all of our audience members know that the Taking Responsibility initiative here at Fordham continues to run webinars of this sort. Of course, we wish that there were not a global pandemic that kept us from seeing each other in person. On the other hand, in the global pandemic, we've learned to be able to bring together people from sunny Los Angeles and perhaps not so sunny UK for a conversation like this, along with other folks on the East Coast like John. But our next event is entitled Jesuits and Boarding Schools, Truth, Reconciliation, and Responsibility. My colleague Catherine has just shared a link in the chat. And of course, there's a horrific legacy with boarding schools for Indigenous, First Nations, Native American individuals here in North America. Pope Francis has recently signaled his openness to engaging with the church in Canada, in particular around the Canadian residential schools. But we have a terrific panel of survivors, advocates, and scholars that will be held on December 7th, again in the same time slot, noon to 1:30 p.m. Eastern. You can register via the link in the chat. And also on the website for the Taking Responsibility Initiative, you will find archived videos, not only of this panel, as soon as we're able to get it up, but all of the previous webinars that we've run over the course of the past year and a half. So it remains for me only to thank our colleagues here at Fordham, first of all, for the technical assistance that they provided with this webinar, and then especially our three wonderful panelists who have given us such insight and so many things to think about. Helen Costigane, John Beal, and Jennifer Haselberger. Thank you all so very, very much for joining us. And we'll look forward to seeing you in one of these other conversations soon. Goodbye.
Yeah, it was an honor.
Thank you.